The Supreme Court on Tuesday had a very big decision on sort of the future of elections and democracy in this country. And what was really important was what they rejected. Hi, my name is David Savage. I cover the Supreme Court for the Los Angeles Times. There has been a Republican theory, particularly after the 2020 election, that the state legislatures really should make the rules and call the shots on elections for members of Congress and the president, because the Constitution actually says, in the 1787 version, says that the rules will be made by the legislature thereof. And they took that literally to say the state Supreme Court shouldn't have anything to do with this. Nonpartisan people, even the governor shouldn't have anything to do with it. It's all us. And the reason that's important is, as you know, our elections have gotten more and more partisan. And there was talk in 2020 that if in one of these very close states, if the Democratic candidate Joe Biden won narrowly, the Republican legislature might say, hey, this is our decision. We're going to appoint electors for Donald Trump, and sort of throw the whole country into turmoil. But it all turned on this theory, unproven theory, that there's this independent power of the state legislature to make the rules. And the Supreme Court knew, I think correctly, that they needed to rule on this in 2023. You wouldn't want this to be hanging in the fall of 2024 at the time of the election. It was important to get this clarified. I think a lot of people thought a conservative court with 6 Republican appointees may well come out on the Republican side of the view, which is that the legislatures call the shots. The court ended up taking a case from North Carolina. This issue arises in different ways. The North Carolina Republicans drew an election map after 2020 that would give Republicans basically 10 of the 14 seats in Congress, 14 congressional seats. Common Cause went to court, they sued, and the North Carolina Supreme Court said, this is unfair. Our voters have a right to a free and fair election. You've drawn this map in a way that they don't have a right to a free and fair election. Republicans are always going to win 10 of the 14 seats. They struck down the map, ordered a new map for 2022. The voters split 7-7. But they appealed to the Supreme Court and said, see what the North Carolina Supreme Court did here? They took away our power, the state legislature's power to draw the election map. That's unconstitutional. You, the Supreme Court, should rule once and for all that the state legislature calls the shots, not state Supreme Courts, not the governor, nobody else. And so that was the issue that came before the court. And as I say, the really big thing was what they rejected. 6 of the 9 justices, liberals, conservatives, basically said, we're going to maintain the system of checks and balances countries had for 200 years, that the state judges and state courts play an essential role. They've always had the role of sort of interpreting their own constitution. We're not going to take that power away from them and say it all goes to the legislature. So they basically upheld the status quo, said that the state Supreme Courts can play a role. And so that's where we are heading into 2024. There's going to be a lot of disputes. We have no idea what they're going to be. They always seem to come up in October, the election year. There's some problem with the ballot. There's some problem with the delivery date of mail ballots or whatever. But the rule now is that the state legislatures, who are supposed to be more nonpartisan, interested in fairness in the election, they're going to have a crucial role in deciding those issues and setting the rules. Early voting and a lot of these issues can become court cases. For example, the Democrats have been more in favor of early voting. The Republicans have been skeptical. Well, what if the Georgia legislature or the Wisconsin legislature on, the fall of 2024 says, we've decided we're going to cancel early voting, no early voting. And the Democrats would want to go to court and say, hey, wait a minute, you can't change the rules and take away the right to early vote. So it would be an election battle on that question. And the issue was, can the state Supreme Court stand up for the voters and say, no, you've had this legal right to early voting, we're not going to let you take it away? Or does the state legislature get to draw say, too bad, we had it last time, we're not going to have it this time. So that's one of, there are really dozens of different types of disputes arise, but that's a good example of one. And there's a lot of disputes on mail-in ballots, the same general issue, which is that this took off during the COVID period, but the Democrats are more in favor of mail-in ballots because it allows more people an opportunity to vote if they have a difficulty getting to the polls or whatever. The Republicans have been skeptical of mail balloting, in part because, you know, Trump always thought that was something that was helping the Democrats. So Republicans are against it. I think it's quite possible that, you know, some red state may decide in the middle of this year, we're going to really tighten up the standards for mail balloting. A lot of little things. They can say you've got to submit a driver's license with your mail ballot, or extra verifications, extra rules. And these cases then go into the courts, and the state judges and state Supreme Court have to say, is this a fair and reasonable rule? Or is this a rule that's really disenfranchising voting and making it hard for ordinary people to vote? So lots of examples down the road, but the big thing is the state judges will at least be in the game.